Hello, this is Ron Climer, and I am with First Real Estate School in Hendersonville, North Carolina. And the purpose of this session is to introduce you to the license law and rules comments. Now, if you don't know, you need to know. Last month, 491 people took the North Carolina real estate exam, which is a two-part exam, and 100 questions are what they call the national portion, and 40 questions are what they call the North Carolina section. Well, you have to pass both halves or you're coming back and paying $164 to take it again, which 49% of the people that took it last month are coming back to take it again. The pass rate last month was 51%. There's a thing in your textbook, in this textbook, if you use this textbook, this is Dearborn's textbook that we use at First Real Estate School, but even if you don't use this textbook, this is a free download from the North Carolina Real Estate Commission's website. It's called the License Law and Rule Comments, and I'm going to read it to you right out of the book, because I encourage my students to read it, but I'm pretty confident that they all don't read it. And I'm going to read it to you word for word. This is session number 1, and it's going to probably take me about 10 or 11 tapes to get it all in here. But here we go. Introduction. These comments are selected North Carolina Real Estate License Law and Real Estate Commission Rule provisions are intended to assist real estate licensees, pre-licensed course students, and others in understanding the license law and commission rules. The comments are organized in a topic format that often differs from the sequence in which the topics are addressed in the license law and the commission rules. The topics selected for comment here are not only of particular importance in real estate brokerage practice, but also are likely to be tested on the real estate license exam. The appropriate references to the license law and commission rules are provided beside each listed topic. Requirements for a license. General Statute 93, that's GS 93 in parentheses. Any person or business entity who directly or indirectly engages in the business of real estate brokerage for compensation or for the promise thereof while physically in the state of North Carolina must have a North Carolina real estate broker license. In North Carolina, a real estate licensee may only engage in brokerage as an agent for a party to a transaction. Thus, a real estate licensee is commonly and appropriately referred to as a real estate agent, even though the latter term does not actually appear in the license law. Note that the real estate licensee is not automatically a realtor. A licensed real estate agent is a realtor only if he belongs to a National Association of Realtors, a private trade association. Thus, the term realtor should not be used to generally refer to all real estate licensees. License categories. There is only one type of real estate license, a broker's license. However, there are several license status categories as described below. Provisional broker. This is an entry-level license status category. A person who has met all the license qualification requirements, including the 75-hour pre-license course and passing the Commission's license examination, is initially issued a broker's license on provisional status and is referred to as a provisional broker. A provisional broker generally may perform the same acts as a broker whose license is not on provisional status, so long as he is supervised by a broker who is a designated broker in charge. A provisional broker may not operate independently in any way. The statute defines a provisional broker as a real estate broker who, pending acquisition and documentation to the Commission of the education or experience prescribed by GS 93, must be supervised by a broker in charge when performing any act for which a real estate license is required. So this license status category is comparable to a salesperson's license in most other states, except that it's a temporary license status category. Provisional brokers may not retain this status indefinitely. They must complete required post-license education, one 30-hour course each year for the 3 years following initial licensure, a total of 90 hours, to remove the provisional status of their licenses and to remain eligible for active license status. A broker. A provisional broker who satisfies all post-license education requirements to terminate the provisional status of such license becomes a broker without having to take another license examination. A broker is not required to be supervised by a broker in charge in order to hold an active license. An applicant who is licensed broker in another U.S. jurisdiction may be licensed directly as a North Carolina broker, not on provisional status, by passing the state section of the North Carolina license examination. All other must be first licensed in North Carolina as a provisional broker and then satisfy the post-licensing education requirements to become a non-provisional broker. Most frequently, brokers elect to work for another broker or brokerage firm. Brokers may also elect to operate independently as a sole proprietor. However, with limited exceptions, such brokers will have to qualify for and designate himself as a broker in charge in order to operate independently and perform most brokerage activities, discussed later under brokerage in charge and also in a subsequent section on brokers in charge that appears near the end of this appendix. Broker in charge, GS 93, defines a broker in charge as a real estate broker who has been designated as the broker having responsibility for the supervision of real estate provisional brokers engaged in real estate brokerage at a particular real estate office and for other administrative and supervisory duties, as the commission shall prescribe by rule. Commission rule blah 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 requires that each real estate office must have a broker who meets the qualification requirements to serve as a broker in charge of the office, and who has designated himself as the broker in charge of that office. As in the case with provisional brokers, broker in charge is not a separate license, but only a separate license status category. A broker who is to serve as the broker in charge of an office, including working independently, must be designated as the BIC with the commission. To qualify for designations as a broker in charge, a broker's license must be on active status but not on provisional status. The broker must have 2 years full or part-time equivalent actual brokerage experience within the previous 5 years, or educational experience the commission finds equivalent to such experience. And the broker must complete a 12-hour broker in charge course with 120 days after designation. Broker in charge requirements are addressed in detail in a separate subsequent section titled Broker in Charge. Limited non-resident commercial broker. A broker or salesperson residing in a state other than North Carolina who holds an active broker or salesperson license in the state where his or her primary place of business is located may apply for and obtain a North Carolina limited non-resident commercial broker license that entitles such licensee to engage in transactions for compensation involving commercial real estate in North Carolina. While the non-resident limited broker will remain affiliated with his out-of-state real estate company and will not have a North Carolina broker in charge, the non-resident licensee must enter into a notification of broker affiliation and a brokerage cooperation agreement with a resident North Carolina broker, not on provisional status, and the licensee must be supervised by the North Carolina broker while performing commercial real estate brokerage in North Carolina. Like a firm license, a limited non-resident commercial broker license is a separate license. Licensing of business entities. In addition to individual persons, business entities also may be licensed in order to engage in real estate brokerage. Any corporation, partnership, limited liability company, association, or other business entity other than a sole proprietorship must obtain a separate real estate firm broker license. Activities requiring a license. Persons and business entities who for consideration or the promise thereof, perform the activities listed below as an agent for others are considered to be performing brokerage activities and must have a real estate license unless specifically exempted by the statute. See subsequent sections on exemptions. There is no exemption for engaging in a limited number of transactions. A person or entity who performs a brokerage service in even one transaction must be licensed. Similarly, no fee or other consideration is so small as to exempt one from application of the licensing statute when acting for another in a real estate transaction. Brokerage activities include 1. Listing or offering to list real estate for sale or rent, including any act performed by a real estate licensee in connection with obtaining and servicing a listing agreement. Examples of such acts include, but are not limited to, soliciting listings, providing information to the property owner, and preparing listing agreement on property management agreements. 2. Selling or buying or offering to sell or buy real estate, including any act performed by a real estate licensee in connection with assisting others in selling or buying real estate. Examples of such acts include, but are not limited to, advertising real property for sale, showing listed property to prospective buyers, providing information about listed property to prospective buyers other than basic property facts that might commonly appear in an advertisement, newspaper, real estate publication, or internet website, negotiating a sale or purchase of real estate, and assisting with the completion of contract offers and counteroffers using pre-printed forms and communicating of offers and acceptances. 3. Leasing or renting or offering to lease or rent real estate, including any act performed by real estate licensees in connection with assisting others in leasing or renting real estate. Examples of such acts include, but are not limited to, advertising listed property for rent, showing listed rental property or prospective tenants, providing information about listed rental property to prospective tenants other than basic property facts that might commonly appear in an advertisement in a newspaper, real estate publication, or internet website, negotiating lease terms and assisting with the completion of lease offers and counteroffers using pre-printed forms and communication of offers and acceptances. 4. Conducting or offering to conduct a real estate auction. Mere criers of sale are excluded. Note, an auctioneer's license is also required to auction real estate. Number 5. Selling, buying, leasing, assigning, or exchanging any interest in real estate, including a household interest in connection with the sale or purchase of a business. Number 6, referring a party to a real estate licensee, if done for compensation. Any arrangement or agreement between the licensee and an unlicensed person that calls for the licensee to compensate the unlicensed person in any way for finding, introducing, or referring a party to the licensee has been determined by the North Carolina courts to be prohibited under the license law. Therefore, no licensee may pay a finder's fee, referral fee, bird dog fee, or similar compensation to an unlicensed person. Unlicensed employees' permitted activities. The use of unlicensed assistants and other unlicensed office personnel in the real estate industry is a very widespread, and the Commission is frequently asked by licensees what acts unlicensed persons may lawfully perform. As guidance to licensees, the Commission has prepared the following list of acts that unlicensed assistants employees may lawfully perform so long as the assistant or employees is salaried or hourly paid and is not paid on a per transaction basis. An unlicensed assistant employee may 1. Receive and forward phone calls and electronic messages to licensee. 2. Submit listings and changes to a multiple listing service, but only if the listing data or changes are compiled and provided by the licensee. 3. Secure copies of public records from public repositories, i.e. the Register of Deeds, office, county tax office, etc. 4. Place a for sale sign or for rent sign and lockbox on property at the direction of a licensee. 5. Order and supervise routine and minor repairs to listed properties at the direction of a licensee. 6. Act as a courier to deliver or pick up documents. 7. provide to prospects basic factual information on listed property that might commonly appear in advertisements in a newspaper, real estate publication, or internet website. 8. Schedule appointments for showing property listed for sale or rent. 9. Communicate with licensees, property owners, prospects, inspectors to coordinate or confirm appointments. 10. Show rental properties managed by the employee's employing broker to a prospective tenant and complete and execute pre-printed form leases for the rental of such properties. 11. Type offers, contracts, and leases from drafts of pre-printed forms completed by a licensee. 12. Record and deposit earnest money deposits, tenant security deposits, and other trust monies, and otherwise maintain records of trust accounts, receipts, and disbursements under the close supervision of the office broker in charge who is legally responsible for handling trust funds and maintaining trust accounts. Assist a licensee in assembling documents for closing. Compute commission checks for licensees affiliated with a broker or firm to act as a bookkeeper for the firm's bank operating accounts. Exemptions. The following persons and organizations are specifically exempted from the requirements for a real estate license. A business entity selling or leasing real estate owned by the business entity when the acts performed are in the regular course of and incident to the management of that real estate and investment therein. This exemption extends to officers and employees of an exempt corporation, the general partners of an exempt partnership, and the managers of an exempt limited liability company when engaging in acts or services for which the corporation, partnership, or limited liability company would be exempt. 2. A person acting as an attorney in fact under a power of attorney from the owner authorizing the final consummation of performance of any contract for the sale, lease, or exchange of real estate. Note, this limited exception applies only to the final completion of a transaction already commenced. The licensing requirements may not be circumvented by obtaining a power of attorney. Number 3, an attorney at law who is an active member of the North Carolina State Bar only when performing an act or service that constitutes the practice of law under Chapter 84 of the General Statutes. Thus, the attorney exemption is strictly limited, and the attorneys generally may not engage in real estate brokerage practice without a real estate license. A person acting as a receiver, trustee, in bankruptcy, guardian, administrator, executor, or any person acting under a court order. Number 5, a trustee acting under a written trust agreement, deed of trust, or will of trustees' regular salaried employees. Number 6, certain salaried employees of a broker property manager. See Chapter 93 for details. An individual owner selling or leasing the owner's own property. And number 8, a housing authority organized under Chapter 157 of the General Statutes, and any regularly salaried employees with regard to sale or lease of property owned by the housing authority or to the subletting of property which the housing authority holds as tenant. The Real Estate Commission. The Real Estate Commission consists of 9 members who serve 3-year terms. 7 members are appointed by the governor and 2 are appointed by the General Assembly upon the recommendation of the Speaker of the House of Representatives and the President pro temp of the Senate. At least 3 members must be licensed real estate brokers. At least 2 members must be public members who are not involved directly or indirectly in the real estate brokerage or appraisal business. Purpose and powers. The principal purpose of the Real Estate Commission is to protect the interests of the members of the general public in their dealing with real estate brokers. This is accomplished through the exercise of the following statutory powers granted to the Commission. 1. Licensing real estate brokerage and brokerage firms and registering timeshare projects. 2. Establishing and administrating pre-license education programs for prospective licensees and post-license and continuing education programs for licensees. 3. Providing education and information relating to the real estate brokerage business for licensees and to the general public. 4. Regulating the business activities of brokers and brokerage firms including disciplining licensees who violate the license law or commission rules. It should be noted that the Commission is specifically prohibited, however, from regulating commissions, salaries, or fees charged by real estate licensees, and from arbitrating disputes between parties regarding matters of contract, such as rate and or division of commissions or similar matters. See Chapter 93 for details. Disciplinary Authority. The Real Estate Commission is authorized to take a variety of disciplinary actions against licensees who the Commission finds guilty of violating the license law or commission rules while acting as real estate licensees. These are reprimand, censure, license suspension, and license revocation. The license law also permits a license under certain circumstances to surrender his or her license with the consent of the Commission. Disciplinary actions taken against licensees are regularly reported to the Commission's periodic newsletter, which is distributed to all licensees and may also be reported in local and regional newspapers. It should be noted that licensees may be subject to the same disciplinary action for committing acts prohibited by the license law when selling, leasing, or buying real estate for themselves, as well as committing such acts in transactions handled by agents for others. The Commission also has the power to seek in its own name injunctive relief in Superior Court to prevent any person from violating the license law. A typical example of when the Commission might pursue injunctive relief in the courts is where a person engages in a real estate activity without a license or during a period when a license is suspended, revoked, or expired. Any violation of the license law or commission rules is a criminal offense, misdemeanor, and may be prosecuted in a court of law. However, a finding by the Commission that a licensee has violated the license law or commission rules does not constitute a criminal conviction. Prohibited acts by licensee. Chapter 93, GS 93, provides a list of prohibited acts which may result in disciplinary action against licensees. Discussed below are various prohibited acts except for those related to handling and accounting of trust funds, brokerage responsibility for closing statements, and the failure to deliver certain documents to parties in a transaction, which are discussed in the subsequent sections on general brokerage provisions and handling trust funds. Important note, the provision of the license law relating to misrepresentation or omission of a material fact, conflict of interest, license competence, handling of trust funds, and improper, fraudulent, or dishonest dealing generally apply independently of other statutory law or case law, such as the law of agency. Nevertheless, other laws may affect the application of a license law provision. For example, the North Carolina Tenant Security Deposit Act requires an accounting to a tenant for a residential security deposit within 30 to 60 days after termination of a tenancy. License law provisions and commission rules require licensees to account for such funds within a reasonable time. Thus, in this instance, a violation of the Tenant Security Deposit Act provision would also be a violation of the license law. Similarly, the law of agency and the law of contracts, as derived from the common law, may impact the application of license law. Thus, a licensee's agency status and role in a transaction might affect the licensee's duties under the license law. Example of how an agent's duties under the license law may be affected by the application of other laws are included at various points in this section on prohibited acts by licensees. And I'm going to stop right there. This is Ron Climer, and this is number 1 in a series of tapes and messages of me continuing to read this 22-page document. So if this is doing you some good, would you please go down to the likes and check like. If it's doing you a lot of good, would you leave a comment and say, gee, thanks, Ron, for putting this on YouTube for us. And if you think it might do your classmates some good, share it on your class Facebook page. I assume that your class has a Facebook page because most of my classes have a Facebook page. So this is number 1. We're going to be back with number 2. Well, it's already here.